Hi everyone. I'm Vittal Rao, legal and management consultant in Bangalore. Today, I would like to share one of the important things of what HR and everybody must be aware to enhance their competency in domestic inquiries. Friends, all of you are highly experienced in area of domestic inquiries. Probably you have conducted a lot of domestic inquiries and you have also worked as or functioned as management representatives, or some of you would have prepared the documentations for disciplinary steps, including preparing the management representative and also briefing the inquiry officer about all these things. So, as you know, domestic inquiry has been a highly technical and also highly logical, because as you are well aware that any inquiry must be done with in line with principles of natural justice. So, if any technical difficulty happens, nowadays we find that the inquiries are judged as bad in law by the courts, and it has a lot of repercussions. As you know, you have to take them back with backwages and whatnots. So today, of course, since all of you are knowing about the entire domestic inquiries, I want to just give one or two tips of how to enhance our competencies in conducting domestic inquiries. That's only my intention today. I will have briefed on you. This is what I call it as relevance of Indian Evidence Act in domestic inquiries. This I will take you through on the presentation. Hold on for a minute. I'll share the screen. Yeah, friends, relevance of Indian Evidence Act in domestic inquiries. Of course, all of us are very well aware that strict observance of Evidence Acts are not applicable to prove or disprove any acts of misconduct before it was. So it is a settled case. The Evidence Act will not strictly applicable. There is no doubt about it. There is no doubt about it. In this direction, I also shared you some judicial decisions in this matter. Take, for instance, in case of Children Railway, Supreme Court has held, it is now a well settled principle of law that principles of Evidence Act have no application in a domestic inquiry. They are very clearly said. Secondly, in the case of Maharashtra State Board of Secondary and High School, High Secondary Education, again the Supreme Court has clearly held, it is thus well settled law that strict rules of Evidence Act and the standard of proof envisaged therein do not apply to domestic proceedings or domestic criminal. It is open for authorities to receive and place on record all the necessary, relevant, cogent, acceptable material facts, though not proved strictly in conformity with the Evidence Act. So this principle is very, very clear. Now let us look at it. Now, for the last couple of years, we have seen enormous development in terms of technology, like for instance, in the IT technology and the social media, so many things have come. So a lot of we rely upon a lot of evidences through the electronic media. This is a recent development. Now, in these circumstances, how far we can enhance our competency in reaching our excellent level in the conducting of inquiries. Although Supreme Court has said not clearly, but even then, now let us look into this. What is the latest position on this? As I said already, Today we use CCTV production, recordings, photographs, CD, WhatsApp, email, and virtual documents, dialogues, etc. We are all using nowadays for the last couple of years. And how far these evidences by either parties? That is the reason. Although, as I said already, no relevancy, can we look at how far we can enhance our competency in presentations before the inquiry? To be, let us be perfect. That's all I'm trying to tell you is that we should reach the level of perfection in all the cases, though it is not signified, let us say, fully intelligent. Now here, in the Evidence Act, Section 65B is there, admissibility of electronic records. Now, this is one thing which has been introduced somewhere in 2020 or 21. Admissibility of electronic records in legal cases. In this case, let us look at the judgment of Supreme Court, where they said that it is a condition precedent to admissibility of evidence electronic recording evidence. It is a condition precedent. It means that subject to certain conditions, the electronic records will be admissible as evidence. So this is the kind of thing. This judgment arose in reference to the division bench of Supreme Court, which found that the division bench judgment of Shafi Mahab versus State of Himachal Pradesh required consideration of considering view of the three-judge bench in Anwar PV and PV Bhaskar's case. Let us look into this. Now, admissibility. What is this section 65 talks about? Let us see. What they say is that any information contained in an electronic record, number one, which have been stored in a system or recorded in a system or copied as a computer output shall be deemed as a document, but shall be admissible as evidence without further proof or production of original if the conditions mentioned are satisfied. This is very important. The condition must be satisfied, then it will be easy for us to look at those things. Let us see what is the conditions and all that. What the section 65B4 clearly states is a very, very simple thing. It is not at all a complicated issue in doing that. What they say, a certificate shall have to produce which identifies the electronic record and gives particulars of device involved in the production of electronic record. A certificate is required by a person who is holding the kind of a system, a certificate from him. That's it. And this certificate shall be signed by a person who is occupying a responsible official position in relation to the operation of the relevant device and from a person who is in the management of relevant activities involved. This signature shall be evidence authentic the certificate. The moment he signs it, it is taken as authenticity, and also he will certify to the best of my knowledge and belief this is true. I will give a simple example. Let us take, for instance, you are relying upon a CCTV footage to prove or disprove an incident what has happened in the company. You are conducting inquiry. So CCTV footage, you have to take it as a part of evidence. What these conditions is that a person who is in charge of maintaining the system of CCTV, you get a certificate from him. So and so and so ask me to give a footnote recording of this, of the day and time, etc., etc. I certified that I have copied this and then produced this. That's it. Is it not simple? This is exactly what section 65A talks about. This is very, very simple. So if we do this kind of a small, simple exercise of taking a certificate from a person, I think the problem is over. It means that we have reached a high level of competency and nobody can question about it. You don't need to be safer side. What I'm telling you is all to be in the safer side of it. Now let us take what are the types of evidences and oral evidence and documentary evidence. We rely upon. There are two things in documentary evidence. One we call it a primary evidence, and another we call it a secondary evidence. Okay, let us look at the primary evidence. Primary evidence means what? Original complaint copy, we have seen it. Original charge sheet, original attendance sheets, original job cards in case of production matters, original statement of witnesses during adducing evidences, like the above documents, etc. This, what we do is that we produce these originals through a witness, through a word, when give word, this will be marked as exhibit, and it is called primary evidences because everything is original. And this is produced by, preceded by oral evidence by the respective officer or person, and produce this as an exhibit. It is called primary evidences, right? Now, what are first category of secondary evidence? The secondary evidence. Here, what we do is that we print a copy of the standing orders or service rules or policy of the company, whatever we have. That is a copy. Again, this is produced by one of the witness or person who is holding it. Here produced. It is only a copy of it. Then copies of previous warnings and records. A person has been punished earlier, has been punished. Those copies are given as produced in inquiry, and they are all secondary evidences. Then copies of medical certificates. In case of absence, you got copy, then we produce it. This is called as secondary evidences. Of course, these documents are produced by deponents while adducing their oral evidences, etc. See, this is very easy. This is first category of secondary evidence. What is the second category? Second category, I told you already about the CCTV footages, CDs, voice recordings, photographs, copies of documents in which versions are not available or versions cannot be produced due to security and confidentiality reasons. So these things also, documents produced by deponents. Normally, we ask one of the deponent to produce these documents, maybe the complainant or somebody who produces all these things. It is taken. But here what happens? Now the acceptability evidence, the condition must be satisfied. Here what happens? Produce the second category document, which anybody produces it. He is producing not from his domain. He borrows and he gives it. But the thing is that the conditions which I talked to you earlier, it has to be certified. It means that a certificate should be obtained by him. For instance, CCTV footages, that can be obtained. CCTV, voice recordings, photographs, person who has taken photographs, he can do it. Then copies in which the originals are not available, you can take out a computer print and show it to him. But all these things must be, what you call, conditions must be certified. That means that a certificate must be obtained. That's all what it says. Very, very simple, right? A very simple thing. So here, very simple, I told you already. Certified official who is in charge of operation, who has executed such work, or who has taken photographs, or who has recorded and taken out from a system, and who has received the WhatsApp, all these things. So if a certificate is obtained, then we are adhering to the section 65B stipulates the judicial and also the judicial interpretation by the Supreme Court, saying that a condition precedent is required. Acceptability of documents, condition precedent, these are the conditions. So, gentlemen, this is very, very easy to observe. It is very not at all difficult, not at all difficult. You will appreciate this. So, this one I am just putting into everybody's attention here so that you can always enhance your level of competition. So, electronic has used the evidence 62, the 65 of the Evidence Act. This process is not difficult. In fact, very easy. For instance, when we submit Xerox copies of our Aadhaar or PAN or GST certificates or cancelled checks, etc., what we do, we make a self-certification and submit it, right? Authorities will ask, please self-certify and then give it, then I will accept it. What does it mean? It means that I am certifying that I am the owner of this, I am giving a copy which I'm self-attesting and giving to you. On the same lines here, gentlemen, we have to do. Here, what happens when we can get certificate process in person, then the matter is over. This is all. This is a very, very simple thing which I thought I should tell you. Because nowadays, proceedings in a ministry inquiry, getting technical, as told you in the beginning itself, it is technical bit due to in the world of IT and computerization. Hence, that we comply with this. It is not difficult. So, but ensures potential lapses in the investigation. We don't know what the course is going to talk about in this digitalization and IT and computerization era. We don't know what they're going to talk. Before that, we prepare ourselves and adopt this. It's a very most simple thing. If we do it, then our inquiries are extremely good. So with this, I end this session. Thank you very much. And thank you very much. And I thought I should share with this information to you all. So I hope it is going to be useful and helpful to you. So goodbye. Good day to you all. All the best. Thank you.